You're listening to the Subrogation Support Network, a podcast from Matthiesen, Wickert Lehrer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host of the Subrogation Support Network podcast, powered by Matthiesen, Wickert Lehrer, your top choice for subrogation. Today, I am honored, and it's my pleasure to have as my co-host, Gary Wickert. Gary is a fellow shareholder at the firm, Matthiesen, Wickert Lehrer. Gary is a titan of the subrogation industry and literally wrote the books on subrogation. He's the author of the Workers' Compensation Subrogation Treatise, the Auto Subrogation book, Coverage book, Health and Disability Subrogation, and my favorite, Where's the Beef? All about subrogating livestock claims, which we're actually going to have another podcast on that topic in a few weeks with attorney Mark Sullivan with our firm. So also, a few other things to add about Gary is, Gary is one of the leading authorities on subrogation. He's a founding member of our firm. And truly, he is the subrogation man. Not just that, Gary's a personal friend of mine. He's right down the hallway from me, but he hears me yelling all day. And also, he's been a mentor to me since I entered the legal field. So, it's really a pleasure to have you today, Gary. So, some years ago, Gary published an article. It was titled, "The Top 10 Subrogation Mistakes That Carriers Keep Making." And it really took the industry by storm. And since that time, Gary's presented this at numerous conferences, webinars, different types of presentations, and it's just a fascinating topic and conversation to have. So, Gary, let's go right into it.
Thank you. I appreciate that. It's a little strange. I can't even tell you how many webinars and seminars. I've been on radio programs, YouTube guests, but I've never done a podcast. This is where we can tell jokes and stuff. Is that right?
Yeah, you can. Do you have one prepared?
No. It's funny, and I hate to even mention it because it makes me feel old. But we started this firm, and its underpinnings started back in the 1980s, early 1980s, and literally nobody was paying attention to insurance subrogation. Nobody was pursuing recovery, and it just looked like there was a desperate need for somebody to help shepherd all these insurance companies through maximizing their recoveries. Over the years, and you know this as well as anybody, we have seen a pattern of things that have been done by some of our clients or our clients' clients. In the case of TPAs and subrogation vendors, we have seen things not done by our clients that have cost them a considerable amount of money. And the scary thing to me, as I started to notice a pattern of things that were happening over and over, is that really nobody knew that it was happening, because it happens surreptitiously. It happens in the handling of a claim in which there may or may not even be any mention of third-party liability. And ultimately, somebody gives themselves a grade on subrogation efforts or simply marks a file, no subrogation. And all is well with the world, except there was subrogation. And I think you know this, but I usually at seminars and webinars talk about the fact that, and it is not coincidental, that the 4 largest subrogation recoveries we've ever had, and those have all been in the 8 figures, have been in cases in files which have been marked no subrogation. Now, that's telling, because it leads to one of the many mistakes that we see made over and over. So eventually what I did, and with some trepidation, I made a short list of things that we were seeing over and over, and I addressed it with clients during client visits or in-house seminars or question and answer sessions. And then it became apparent to me that I was seeing the same bunch of mistakes over and over. And so what I did, and I did this with a lot of feedback from a lot of the MWL Subro attorneys, is I sort of compiled a list of the top 10 mistakes that we have been seeing over and over, and ranked them, actually, not just out of convenience, but ranked them based on, number one, the frequency with which we saw that particular mistake. How serious of a mistake is it? How often is it repeated? And number two, how much it costs the client in terms of lost subrogation dollars. And that led me to that article, top 10 mistakes that insurance companies, subrogation mistakes that insurance companies keep making. It is probably one of our most reprinted articles, printed in claims journals, printed in trade magazines, printed internally within insurance company communications. And eventually we were asked to go out and speak on these top 10 mistakes, and did. We spoke at Executive Summit, we spoke at NASP, we spoke at a number of organizations. And each time, I have to, be a little honest, I felt a little sheepish, because while you and I have a good deal of experience handling subrogation litigation, we have, I think, a great acumen in our ability to help counsel clients. We've never run an insurance company. I would no more know how to run an insurance company from the ivory tower on down than to build a nuclear bomb. So when I spoke at Executive Summit, and I'm looking out at some 850 executives within the insurance industry, and I'm telling them what they're doing wrong, trust me, I was a little nervous. And I did get some negative feedback. Well, you don't understand, Mr. Wickert, that we have to make ends meet and we can't spend money on this or investigation on that. And I totally get that. And what we're not telling insurance companies is that they have to spend money or spend time, because the two are equivalent, on pursuing subrogation in every file in which they sense there may be subrogation, but they at least have to recognize it and make an informed decision on whether or not it's going to be cost effective to pursue.
Absolutely. And it is interesting that in a lot of ways, when this has been presented, and as a side note, I have actually, I don't want to say stolen, I've borrowed this presentation and I presented it to numerous clients. A lot of times when we're onboarding a new client, to kind of get them up to speed with, hey, here's what we do at MWL, here's our thoughts, here's what you can do better. And it is kind of strange on some of these to go forward and say, hey, here's what you're doing wrong, right? Hey, new client, hey, client who's paying our bills. This is what, this is why you're wrong. But ultimately what it is we bring these forward, and Gary put these together so that we can show this is what you can do to do better. And doing better means you're bringing in more money for your carrier, right? It's all dollars and cents here.
You remember the movie Jerry Maguire?
I do.
Cameron Crowe was the director, and it was, I'm not a romantic comedy guy, but this one really caught my interest. It had a lot of really, really humorous parts, and obviously some little memes that we have entered the public sphere. You show me the money and all that kind of stuff. Jerry Maguire, played by Tom Cruise, it starts off with him writing a 5,000-word mission statement. And, he wrote that for his, for the agency, the sports agency that he worked with. He was a sports agent, and he entitled it "The Things We Think and Do Not Say." And he took some heat for it. He got fired, and he had to go start his own sports agency. But all along, I think Jerry endeavored to improve the profession, and that's what we are intending with this. It isn't meant to be a critique, and it isn't meant to be, critical of our clients. It's meant to advise them that there may be some things that they could do cost effectively that will help them bring in a lot more money.
100%. So let's jump into one of those. So the first one on the list here is the delay of game penalty and waiting too long to involve subrogation counsel. I think that this is a huge, huge issue in the industry, because too many carriers, too many TPAs, adjusters try to hold these claims in-house for months or years sending template demand letters once every 3 or 6 months. And then they question, hey, why aren't we going anywhere? Or they wait until the last second to refer the case to us. And, I will note we have trained 99% of our clients to not wait until the day of the SOL to get us the case. But there are many other concerns that come into play. Gary, why don't you tell me a few of those concerns and why this is number one on your list of top 10 mistakes?
There's no question it's number one. I call it delay of game penalty. Yeah, kind of cute, but it essentially you're waiting too long to involve subrogation counsel. I reflexively kind of wince a little bit when I say things like you waited too long to involve subrogation counsel, because it sounds like I'm fishing for business. It sounds like I'm soliciting work, and I'm really not. What I'm trying to do is let the client know that there is a serious penalty for delaying the subrogation game. This particular mistake, delay of game, it's number one because it is the mistake that we see most prevalently. It's the mistake that I think affects the majority of the files that we see. And it is, I guess I could just say it's human nature. People reflexively want to avoid sending work to an attorney because they go, oh, well, there's a fee if you hire the attorney. And that's true because we have, we have bills to pay too. But ultimately, the cost of delaying, I think, is underestimated and under-recognized. It's one thing to sit on a $3,500 MedPay claim and wait for the bodily injury claim to resolve itself, and then hopefully you get a check. But it's quite another to sit on a $350,000 work comp subro case in which you're kind of hoping that the plaintiff's attorney will just, at the end of the day, say, hey, why don't you take 300? And you pump your fist and go, yes, victory. That doesn't happen. And
how about those product defect cases where, we get that case too late in the game, and next thing you know, we have to file suit and find out later on that there's another party, a distributor, a retailer, another manufacturer that has to be added. I mean, there's so many ways that this comes into play that can truly, destroy a viable subrogation case.
Yeah, the passage of time is like radioactivity on a claim. You notice periods are lost. Notice periods statutorily, say for work comp. Notice periods within various states, PIP and MedPay subro statutes. Notice periods to municipalities in order to avoid the immunity. So nothing gets better with age in the world of subrogation. Witnesses disappear. People are paid off with their claims. The insureds don't want to help anymore. Everything goes to hell in a handbasket if you wait too long in a subrogation case. It's number one in terms of the amount of times we see it, and it's number one in terms of the dollars that we lose as a result of committing it.
Yeah, and I just had a case last week, a new client sent over, and it was one of the states where we had a 90-day notice period, where if the carrier was going to pursue the work comp case independently, we had to give 90-day notice prior to the SOL running. Well, guess what? We were, I think it was 48 days out. So I had to go back and say, hey, there's nothing you can do here aside from trying to convince claimant to pursue. But if you got us this case, 120 days prior to the SOL, we could have done something. So lots of things here,
There are municipalities that have a 30-day requirement. Think about that. The city of Austin used to be like that. There's some other cities, one in Alabama. Their charter and their ordinances, 30 days notice. Accident involving a police car, accident involving a government plow, or you have 30 days. 30 days. Think about how fast that goes by in the life of an insurance claim. You're right.
It's crazy. And it's with the 50 states and all the variants. It's really tough for an adjuster or even an attorney to know unless they know where to look or have this appropriately docketed. So get subrogation counsel involved early. And as Gary said, it sounds self-serving, but it isn't. It's just the number one good rule. The fact is, if you have trusted counsel, and that should be, if we're going to put an 11 on here, I'd say have counsel that you absolutely trust. because you shouldn't be concerned about them having self-serving motivations, right? When I build a client relationship, I'm going to be doing this for years. So I'm looking for the long term, not the next year profitability, but I'm looking to build a relationship for the next 30 years, the next 40 years, maybe. By that time, I don't think people will retire anymore.
Well, that's right. That's right. And I've got to mention that good subrogation counseling, I do this all the time, and I know you do too. If I'm referred a file and I look at it, my advice sometimes is send a lien letter here, send a notice letter here, and then diary for 90 days and see if you get your money. I don't automatically say, okay, we'll open this file. Please acknowledge the fee agreement. Because like you say, this is we're playing the long game here, and we want good relationships with our clients.
Absolutely. And all the time I'll go back to clients and say, hey, I'm happy to take this case today, but in reality, here's a legal argument. Just toss this in the demand letter, see if you can get it done. Guess what? They get it done. Sure, we don't get the fee, but we build that client relationship and we show our clients that, we can be trusted. And that's one thing. When you have counsel that you can trust, you don't need to worry about getting the case to them too early. We'll tell you that. The worst thing you can do is wait till it's too late, because oftentimes that means it's actually too late. And one, your case is going to be worth far less, or two, it's going to be worth nothing. So let's move on to the next one, Gary. Number 2, it's failure to recognize third-party liability. Tell me a little bit about this one.
Yeah, I refer to it kind of tongue-in-cheek as, quote, a hot cup of McDonald's coffee. And I do that because everybody knows about the McDonald's hot coffee case. Everybody laughs about it at the water cooler, in the bars, and at parties. They're talking about this woman who was dumb enough to not realize her coffee was hot, and she made millions of dollars. I use that example because in the world of subrogation, our clients have to be able to recognize third-party liability. This is one of the more difficult, and it's not well known or it's not well recognized that it's that difficult, but it's one of the most difficult because it involves at least a superficial understanding of tort law in 50 different jurisdictions. You have to understand when and how liability might attach. I can't tell you the number of times I've seen files in which they said just simply no subrogation without even any investigation, without talking to the insured, without talking to witnesses who are listed in a police report. So when I cite the McDonald's hot coffee case, it's because we all think it's the poster child for tort reform, but it isn't. Just real quick, the facts of that case that not a lot of people know are that this 79-year-old grandmother, Stella Liebeck, she received third-degree burns over 16% of her body, hospitalization for 8 days, whirlpool treatments, debridement. All of this stuff is excruciatingly painful. And she wasn't driving. She wasn't negligent. Her grandson was driving. He pulled over. She attempted to open a cup of coffee, opening the lid front to back so she could add some sweetener and some cream to her coffee, and it spilled. It happens. But because McDonald's has a corporate requirement to have its coffee at 180 to 190 degrees, while most restaurants serve coffee at 160, at 180 to 190, it automatically causes third-degree burns. The skin is burned down to the tissue in 2 to 7 seconds. I think she was wearing some sweatpants that sort of absorbed the hot coffee. So they had this requirement. And then on top of it, when they got to trial, oh, by the way, she offered to settle for 20 grand. And they just said, for medical expenses. And they said, well, no, we're not going to pay that. And McDonald's on the stand admitted that the coffee wasn't fit for consumption when it first gets passed to the consumer in their car, or they walk out of the McDonald's with it. So there's more than meets the eye here, but this is why it's a great example that we as an industry have to shed our instinctive, and they serve us well, but our instinctive proclivity to limit liability. We have blinders on when it comes to recognizing subrogation, because for so many of us in the insurance industry, our lives revolve around limiting liability, paying as little as possible, pointing out when people are malingering, faking, or just in it, as gold diggers. And I think that defense myopia can bleed over to subrogation and cost us money. So I use that case as an example, not as a the poster child for tort reform, but more like the poster child for subro.
Right. And as you know, and most of the listeners know, I mean, I go around training on negotiations, and I train carriers, speak at conferences. And one of the first negotiations tips I give to subrogation people is to think like a plaintiff's attorney. And you can see in the room when I say that there's some gasps, there's some boos, there's a few people that walk out, and not really, but I'm sure there has been. And it's almost just antithetical to just what the industry is trained to do. It's to limit liability. It's to have this defense myopia. And ultimately, our role in the subrogation field is to think like a plaintiff's attorney. It's to put that hat on, right? We're not going to be going out there chasing ambulances, but we have to be willing to get creative and recognize third-party liability where maybe it doesn't seem to exist up front, right? Every claim isn't going to be a rear-end collision or just an obvious fire caused by maybe a dehumidifier. There's going to be factual scenarios, and the majority of cases are going to be those scenarios that are in the gray area, right? Those are the ones we see, of course, because we get claims that are typically denied. But ultimately, it's always encouraging folks, think like a plaintiff's attorney, put that hat on. We're building a narrative. We're creating a story. We're finding ways to create liability where it didn't necessarily appear to exist on its face. That's why a lot of times I train frontline adjusters, and I have a presentation that I give to most of my clients. And we don't just train the subrogation folks. We're training those people that are on the front line, adjusting those claims to be able to identify subrogation so that it then goes to the right people. There's more and more claim software now that are actually running reports and kind of using AI to call data with algorithms and so forth to find these claims. But there's nothing like that adjuster at the onset taking a look, saying, hey, sure, this isn't a rear-end collision. Maybe our driver rear-ended the other vehicle. Hey, but guess what? That vehicle hit the brakes too fast, or this or that or another thing that can create a narrative so we can build a story and facilitate a recovery. Because we don't need 100% liability on the other side to have a good recovery. There's states, Florida just changed, but there's some states that are still pure comparative, right? Where even if we're 90%, our insured's 90% responsible, we can still recover 10%.
Right. And we don't suggest that clients ignore that. We're not suggesting, hey, pursue liability when none exists. And we're not saying pursue crappy subrogation cases. What we are saying is, recognize when there is liability. You mentioned a rear-end collision. The largest recovery I personally have ever had in the state of Texas, where I practiced for 20 years, was a case in which our employee was driving down the freeway at highway speeds at 4:00 in the morning and ran smack dab into the back of a cement truck. And we sued the cement truck because we rear-ended him. And everybody kind of gets, in the audience listening now, gets a little uneasy, like, wait, how did that happen? Well, you have to look a little further. Just because it's a rear-end collision doesn't mean there isn't subrogation. This particular truck had 2.5-inch round red taillights that had been crusted over with dry cement. And he was still in second gear after about 1,300 feet, traveling about 30 miles an hour. In Texas, it was 70-mile-an-hour speed limit. So never just assume that there's no recovery. Always look, always put on that plaintiff's hat.
That's the truth. And actually, Steve Smith and I, another attorney with the firm, I did a podcast just a few weeks ago on auto subrogation, and I gave you a shout out, and I gave that example for a similar scenario. So no, that's an excellent example. And there's just so many more where you can't have a proceduralized or a formulaic basis to subrogation claims. We need to think outside of the box, and we need to truly get creative in some of these situations. And that helps with, obviously, one, being able to be creative, and two, knowing the law. Nobody's going to know the law in every single state, right? But it's about knowing where to find those rules, knowing how to research. And that's one thing where I refer everyone to the mwl-law.com website, because we have all those charts, resources, and different things you can take a look at. So thanks for that one, Gary. So number 3, and frankly, I think this is probably one of the most important in my mind. This may even be number 1 if I would have put this together now, just because I see this as an issue so often in this day and age. And that's the lack of a timely, thorough subrogation investigation. Gary, let's jump into this one.
Yeah, well, I'm not going to disagree with you. The reason I put it at number 3 is because, and it's a simple function of the English language, in order to thoroughly investigate subrogation or pursue subrogation, you have to first recognize it. Ergo, mistake number 2, the McDonald's hot coffee thing. But yeah, you're absolutely right. The biggest, maybe in terms of volume, aside from waiting too long to refer the file, which in itself could be a failure to recognize timely, the lack of thorough and timely subrogation investigation, I would say, infects to some degree 80% or more of the subrogation files we see referred. And it doesn't mean that nobody took any subrogation action. It doesn't mean that the claims handlers or the subrogation department isn't doing its job. What it does mean is that maybe they didn't ferret out that eyewitness whose name but an incorrect phone number was listed on the police report. Maybe they didn't take time to take a few photographs of the broken concrete where the employee fell, or observe somehow a traffic pattern with the traffic lights. You can really do a great deal of deep diving on some of these subrogation investigations, and unless you do that, we're going to oftentimes get the file when things are gone. Surveillance video has been deleted. Dash cam video is unavailable. Witnesses have moved, especially in Texas, where there was a lot of transition between Texas and Mexico. I can't tell you the number of times a viable witness had returned to his or her native country of Mexico. And then things get really dicey, where that does detrimentally affect subrogation potential, if not destroy it altogether.
Right. Think about products cases, right? A product liability case and not retaining the evidence. And this is where we see this all the time, where maybe that frontline adjuster didn't recognize subrogation, never even looked into it. The subro department doesn't get this case until 3 months after the loss, calls up the insured. Hey, we need the toaster. Oh, the toaster's been thrown away. Or no, yeah, we kept the toaster. It's in the garage. But next thing you know, we don't have any of the other evidence. We didn't send out a fire investigator. We didn't retain a mechanical or electrical engineer. So there's so many things that come into play that investigation, I think as Gary mentioned earlier, the time and energy spent investigating the case is going to be directly proportionate to the amount of recovery that we have. And the cases that we have that are, truthfully, we tell clients, sorry, you would have had a slam dunk case, but we had to shut this case down because you didn't retain the evidence. There's not much we can do about it.
Exactly. And you mentioned the products. Okay, suppose someone is listening to this podcast and the next claim they have involving a potentially defective product, they go out and they retain the toaster oven, the General Electric toaster oven, through which the C&O, or actually the origin expert, looks and says, we think your fire started here based on the fire patterns, et cetera, et cetera. Great. Now you've got the product. But wait, there's more, because the defendants aren't going to roll over and say, yes, it was our toaster oven. They're going to say, no, it was the outlet, or it was the mix master that was next to the toaster. Did you happen to preserve those too? No. Well, there you go. Now the jury's going to have a question in their mind, and all it takes is a couple of them to say, well, they didn't prove that it wasn't the mix master, or they didn't prove that it wasn't the cigarette that was next to the toaster oven. So you also have to preserve evidence that may not be in your favor to prove that it wasn't the cause, because the defense will certainly argue it was, and they will argue spoliation because you didn't save it. and not only save the products, but as you said, Ashton, retain the product, but you have to maintain the chain of custody. If it goes from person to person to person, for me to be able to prove, as is our burden, that it is the product that was in the same condition as when it was purchased and made by the manufacturer, I can't prove that if there's some doubt as to whether it's the same product because it's been through 15 different hands.
Right. And on day one, we don't always know what is going to be viable evidence. What I tell my clients is retain anything that is even potentially related to the claim, right? To the cause, right? That's if we could be absolutely certain that it was that toaster, but if right next to the toaster there was a microwave that also was consumed by the flames, or there was an oven, I'm saying retain it, even if your expert is confident that it's the toaster. Keep everything, or do a scene inspection and get STIPs that everyone can obviously dispose of other evidence. We see it all the time, and Gary gives an excellent story or example when he gives his presentation, often referred to as the parable of the pebbles. And I like to think about this parable as kind of a great, when I'm thinking about retaining evidence, this is a fascinating aspect. Gary, do you want to give us the synopsis of the parable of the pebbles?
Yeah, I love this little story because it smacks true on so many different bases. Subrogation investigation often appears to us in a file dressed in blue jeans and disguised as hard work. And that's because it is. And that's because often you may not recognize that the time and energy you have to spend investigating subrogation in a claim that you already have to adjust the loss in and have 1,000 other files on your desk. But it's human nature to kind of shy away from that because you say, well, this is only a small claim. So it requires only a small amount of investigation. The truth is, whether it's large or small, the claim, the burden is the same. In court, the burden is the same. So we have to commit the same amount of subrogation, and we have to search for any and all evidence. And the parable you're referencing, we call it the parable of the pebbles, but it goes something like this. I don't even know if it's one of Aesop's fables or where it came from, but it really is telling. A group of traveling nomads were traveling in the desert, and they were preparing to make camp for the evening. And suddenly there was this great light that shone down from the heavens. Instantly, the nomads knew that they were in the presence of this celestial being. And they looked up in awe, and a loud voice spoke from the heavens, saying, "Gather as many pebbles as you can, put them in your saddlebags, travel a day's journey. Tomorrow night you will be both glad and sad." And then, as quickly as it appeared, the voice and the light disappeared. Now you can imagine, the nomads looked at one another in disbelief. They had just experienced the revelation of a great universal voice, and they expected some great wisdom, health, happiness, wealth. Instead, the key to the message was to pick up a couple of lousy pebbles and put them in their saddlebags. So they were very disappointed. But despite this menial task that made no sense and dejected, they each picked up a few pebbles and put them in their saddlebags. The following morning, they broke camp. They traveled a day's journey. And that next evening, while they were making camp again, they reached into their saddlebags and discovered that the few pebbles they had bothered to pick up had turned into beautiful and brilliant diamonds. And instantly, the nomads were both glad and sad, because just as the voice had promised, they were now glad that they had a few beautiful and valuable diamonds, but instantly very sad because they had not taken the time to fill their saddlebags with pebbles when they had the opportunity. So the reason I like that parable is because subrogation investigation is much like the opportunity that those nomads were given. When you open your file and it appears that there was a product that may have started on fire and caused this loss, or there was something blew up and injured an employee, you now have the same opportunity that they had. And you might And as obviously it's number 3 on our list of mistakes, so we see it quite often. Quite often you pick up a few pebbles and put them in your saddlebags, when all along that was the opportunity to find that one pebble that would turn into a diamond, that would turn your case into a 100% recovery as opposed to no recovery at all. And I like it because it just reminds us to investigate early and thoroughly, choose the right expert, and we'll talk about that as a separate mistake in a little bit, and insist on reports which pinpoint a cause and an origin. You never know what you're going to find.
Moral of the story, pick up all the pebbles, right, Gary? So number 4, getting what you pay for. Using cut rate vendors and low bidders is more expensive. Now, when I've given this presentation, this can often be a tough one because a lot of times there'll be, various vendors in the audience, those cut rate folks who say, well, we'll handle all your subrogation at 10% and somehow claim that they're going to do the same thing as a subrogation litigation firm. So this can be a tough one when we're giving the presentation, but it's still high on this list. And this is hugely important. The amount of claims that are closed down because they're told by a vendor that's taken 10% that it's not economically viable for pursuit. I mean, it's staggering. And we see a lot of those because we get it on the back end after doing a second look or reviewing. And this is a huge, huge cost to the industry. And the scary thing is most carriers have no idea how much money they're truly losing. So Gary, why don't you go into a little more on that one?
Yeah, I share your sentiment that this is one where I'm a little sheepish in presenting because it sounds like we're trying to tell our clients not to utilize third-party subrogation vendors or TPAs, and that is the last thing we are saying. In fact, I would say a good 40%, 35-40% of our clients, I've never checked, but are actually TPAs and subrogation vendors. And many of those clients of ours go to insurance companies and solicit work by offering a percentage that might be less than what their attorneys would charge them. All right. So I think what I'm saying is that many corporate decisions are made with the best of intentions, but some of those can actually be detrimental to subrogation performance. It's irony at its purest. When you make a decision to save money and it costs you, I oftentimes think about how often the word irony is misused in the English language rather than simply a coincidence. This is irony at its purest. There was a businessman named John Ruskin and I have a quote in the article, and allow me to read it here. It says, "It is unwise to pay too much, but it's worse to pay too little. When you pay too much, you lose a little money, that's all. When you pay too little, you sometimes lose everything because the thing you bought was incapable of doing the thing it was bought to do. The common law of business balance prohibits paying a little and getting a lot. It cannot be done. If you deal with the lowest bidder, it is well to add something for the risk you run. And if you do that, you will have enough to have paid for something better." So what I'm saying is litigation isn't cheap. Not all cases are litigated, but every subrogation case ever has to be evaluated with the end result in mind. And that end result is that 12 men and women on the jury are going to hear the evidence, whatever is retained, whatever your subrogation counsel can present, and they're going to have to present it. So we are approached weekly. And by the way, there are many wonderful, aggressive, successful subrogation vendors, TPAs. We know because they're our clients. They are students of subrogation. They're aggressive. They don't commit a whole lot of these mistakes that we're talking about. So I'm not saying don't use them. What I'm saying is that we're approached weekly by vendors who come to us and say, "Hey, can you handle this case? The statute runs in 20 days and we are having problems finding a lawyer." Okay, well, we look at the file and sure enough, it's several $100,000. It's a complex products case. I had one recently. It was an air crash case 2 years after the loss. So we can go back to the other mistake that we talked about earlier. And come to find out that all they can do, they took the file on a 20% contingency fee. Well, the problem is that lawyers don't just charge a 25% or a third because they like money. They charge that amount because there are hundreds and in some cases thousands of hours that have to be invested into a piece of litigation in order to make it successful. So the speciousness here is the illusion that you're getting more net by paying less. And that's not true. I always use the example, a $75,000 recovery in a $90,000 subrogation case litigated on a 1/3 contingency is preferable to a $30,000 recovery on a 15% contingency. And it's very deceptive. The argument sort of goes against common sense. The argument against entrusting your files to a vendor who say will only pay 22%, and everybody who's on the board or in the decision-making process says, hey, this is better because it's less. It's only 22%. But it's counterintuitive. For example, I use the example of a ball and a bat. If a bat and a ball together cost $1.10, think about that. And the bat costs $1 more than the ball, how much does the ball cost? Most of you are thinking, well, 10 cents. It's simple math. But like most people's instinct on the value of sending off your valuable subrogation files to the lowest bidder, the answer is wrong. Cheaper is rarely better. Litigation isn't a commodity. It's a professional service like brain surgery or engineering. When you need it, you've got to get it right. And if you don't have the investigation, or if lawyers look at a file and they can only spend a certain amount of time before that file becomes upside down for them in terms of at least making a profit. And don't forget, they take the risk on a contingency of no recovery at all after spending thousands of hours. You're going to end up with a bad subrogation result.
And you're truly getting what you paid for, because we do review these files at time from some of these very, you'd say, marginal, more cut rate vendors. And what you see is if they're charging a 15% contingency fee, I mean, they also need to try to find a way to handle that profitably. And what that means is they're not handling it aggressively in the vast majority of situations. I mean, we see cases where, okay, yeah, sure, they're handling it on half the fee that we'd handle it on, but ultimately they're sending out one demand, the same demand, once every 4 or 5 months, and that's it. They're sending out a demand, it goes out, they calendar it for another 6 months. And then they send it to us, 2 days before the SOL runs. And we just, obviously, there isn't time to handle a complex products case with no investigation and just simply 8 demand letters in the file. So it's definitely something, the true cost isn't on the menu. It's a big deal. Beautiful. So keep that one in mind. Now, the next couple we're going to run through, and we're going to run through a little bit quicker because they're not as in depth. But number 5 is called Sleeping with the Enemy, Relying on Plaintiff's Counsel to Protect You and to Protect Your Lien. Gary, tell me a little bit about this one.
Yeah, again, here, insurance companies are doing what insurance companies must do. They have to make decisions based on what's going to be profitable. They're a for-profit company. They have shareholders they have to please. So when an insurance claims adjuster sort of teams up or takes the word of an insured's counsel, a plaintiff's attorney in a case, say, yeah, we'll take care of your subrogation interest. Those perceived savings often turn out to be illusory because, well, while that attorney will pay any legal subrogation claim that you are legally entitled to, trust me, and most of you know this, they will come up with a variety of reasons why at the last minute you're not entitled to that much, or you're entitled to nothing because the money was paid to a minor or was paid for loss of consortium. They can gerrymander cases. Trial lawyers are shrewd. They're successful because they are shrewd, and they suggest arrangements because they know it will benefit their clients. That's their ethical duty. So the idea of a plaintiff's attorney protecting your valuable subrogation interests, it runs contrary to the ethical duty these lawyers have. And I can't tell you the number of files we see where somebody has been shortchanged by a trial lawyer after telling them that they would take care of their subrogation interest.
Absolutely. And then they reach out to us and say, hey, funds were distributed or it was applied to a loss of consortium claim. And what do we do? To which we oftentimes need to reply, you should have had us the file 6 months ago. We should have intervened. And then we kind of go through the education process with that client. It's a huge thing. There's also in the work comp context, quite a few states where, it's truthfully, for all practical purposes, it's free to retain subrogation counsel. There's states where if we have an active role, you no longer have to pay the 1/3 to plaintiff's attorney. There's plenty of other states where we must intervene. There's other states, and the majority of which, I think the majority rule would be we should intervene because there's too many ways for that plaintiff's attorney to gerrymander the settlement. So, obviously paying us 1/3, it's a cost or whatever the fee is, but it's way less than having that plaintiff's attorney apply everything to gerrymander that settlement and you're getting nothing.
Right.
So,
let me just add, because you mentioned it, in the context of work comp, Subro, it's true that in a lot of states where your subrogation counsel is active, you will not be paying a fee to plaintiff's counsel. However, one of the most common questions we get is, Gary, if I send you this file, will I have to pay plaintiff's counsel and pay you? My answer is always the same. Well, it depends. I don't know what has been done. A lot of times the judges look at who did how much work. And the bottom line is that while it may be true that you have to pay plaintiff's counsel 1/3, in a lot of states, you don't have to pay him if he actively works against you. If he comes up with reasons why you shouldn't get your lien, if he gerrymanders the settlement, if he makes legal arguments that are contrary to your interests, he's no longer serving you and shouldn't be paid 1/3. So just be careful, because just because plaintiff's counsel has a statutory lien to pay doesn't mean he has to pay it.
That's the truth. Yeah. And we talked about putting that plaintiff's attorney hat on, but that doesn't mean that we should just be trusting all plaintiff's attorneys willy-nilly. So keep that one in mind. Now on to number 6, detecting and curing the subrogation cancer, failure to discover indemnity and waiver of subrogation. This can be huge, especially when it comes to be it construction context or a lot of times the slip and falls on customer properties. Failure to recognize that there's some sort of contractual limitation to bringing your case, it obviously will destroy your case. And the hard part is if you find out from day one, okay, there's indemnification language or, there's a waiver of subrogation, then you don't have to spend the hundreds of hours working up the case. And it's not that we get that. We serve discovery. We've put in dozens of hours. And next thing we know, there's a contract that our insured already had. Gary, you have anything to add to this one?
Yeah, and we have another, or at least one, maybe 2 or 3 webinars on waivers of subrogation, how to interpret them, how to get around them. If you're dealing with a waiver, I would suggest you look at those webinars. Here, what I'm referring to is detecting and curing subrogation cancer. The cancer is we get a file, we're working on it, and 6 months later, there's an agreement that the insured produces that somehow it or he or she signed that said they're going to indemnify the tortfeasor, or we discover a waiver of subrogation in that agreement, or we discover a waiver of subrogation in the policy itself, something that was never sent to us. Look for those things up front. That's all I'm saying with this particular mistake that we do see with some regularity is just know that all of your time and energy will be wasted if you don't notice the cancer early on.
Absolutely. And now 7, sharing the good news. All right, we finally have some good news. Giving notice to carriers, government entities, and product manufacturers. Notice is huge, and insufficient notice can totally destroy your claim. Now, when we talk about notice, Gary, what are you referring to here?
Here I'm talking about primarily notice to government entities where we covered this earlier as one of the drawbacks of not taking prompt action on subro is you're going to miss deadlines. You're going to miss notice deadlines to government entities, to third parties. You want to put product manufacturers on notice. so they can get involved. You want to give notice to third-party carriers so settlements aren't made without your involvement. Notice is often required in work comp situations, depending on the state, in order for the carrier to file suit. And you, again, here, your jobs as subrogation professionals are not easy. Lawyers have problems. Experienced lawyers have problems getting their mind around the laws of 51 different jurisdictions, having to understand how they interrelate, and how they apply. So this is a quick mistake that we see happening, where simple notice isn't given, or, drum roll, inadequate notice. The government doesn't give up its immunity easily, and sometimes it requires a whole lot of nonsense to be included in a notice letter, or the notice letter isn't worth sending, and it doesn't suffice to meet the notice deadline.
And I get cases multiple times every month, a lot of times from TPAs, sometimes from the carriers directly, where what we find out is, okay, beautiful case, slam dunk liability, defendant is local municipality somewhere, and we get the case. Look, we have the police report, beautiful rear end collision caused by a government employee on the clock. Next thing we know, we look for the notice letters. We keep looking for the notice letter. We look even deeper for the notice letters. We call the client, email the client, hey, when did you provide notice? Where is it? And we find out either one, they didn't provide notice, or two, they just sent an email, and they were even corresponding back and forth. And the fact is, most states don't have constructive notice rules. There's a lot of municipalities that require actual notice, written notice with all of these various requirements on a specific form. And if that isn't accomplished, then sovereign immunity isn't waived, and the government, you can't bring the claim. It's that easy. And we have to tell the client, hey, because of this, your case that was worth quite a bit, probably 100%, is now worth zero. Sorry to tell you. So yeah, that's a huge one. So next one up, 8, crossing state lines for moral purposes, multi-jurisdictional opportunities and pitfalls. Gary, tell me a little bit about the multi-jurisdictional opportunities here.
Yeah, this is something we see that is not only missed by some of our clients, but missed by a lot of lawyers as well. Plaintiffs' lawyers will commit this mistake also, but it's important for our subrogation clients to realize that when you have an accident in Texas and you have an employer, say in Georgia, and an employee who lives in Florida, it's important to understand the conflict of law rules. In Texas, where the lawsuit would be brought, which states' workers' compensation subrogation laws apply? Texas, Georgia, Florida. The beauty of this is that it is not only a tool that we can use if we get the file fast enough, we can use to maximize our recovery, because we can apply the law of a state that might be a little more favorable to our subrogation endeavors. But it also is a tool that, and maybe there's not that many frontline work comp claims adjusters listening, you're more subrogation oriented, but even the claims adjuster, when you get the first notice of injury, can make a decision, hey, if we pay this under Georgia law, we will have the ability to make a recovery, although we'll have to comply with the made whole statute. But if we pay it under Texas law, and the accident is in Georgia, we're not going to have any recovery at all because of some obscure Georgia law, which we don't have time to get into. But the bottom line is the decision you make on which state's benefits to pay when you have that option, and many states have reciprocity agreements between them, so you do have an option, is it could be critical. The decision you make on day one of a claim, you haven't even thought about subrogation, but you decided to pay benefits under the laws of a particular state, and that was the death knell for subrogation in that case. So not only can it be used by us to creatively bypass some bad law in a particular state by applying the law of another state where you have multiple states involved, but it can also be used by the claims adjuster to help set up and position us for a wonderful subrogation recovery down the road.
And that's one of the huge benefits to using national counsel like MWL, is that we have that broad scope, understanding and how to argue choice of law and do conflict of law analysis. I can tell you that quite often on these work comp claims, when we're trying to argue choice of law and have a conflict of law analysis to put into place, I'm negotiating or arguing with a plaintiff's attorney who's practicing in that state where maybe I'm not in. They have no idea what we're talking about, right? They've never considered multi-jurisdictional application, right? That's just not something in their wheelhouse. So it is really complex. It's a difficult thing for adjusters and attorneys to understand, which is why we tell all clients, if there's questions on this, if that comes up, both Gary and myself, we are more than willing to have those conversations with you and give recommendations. Number 9, and this is an important one. Probably this is one of the most important for the comp context, and that's the idea of stepping over dollars to pick up dimes and waiver of liens to settle workers' compensation claims or EL claims. Gary, tell me why this is so important.
Yeah, let's take in a work comp scenario. You have the claims adjuster adjusting the work comp claim, and their number one objective, of course, is to pay as little as possible while following the law and in good faith paying benefits. And then number 2, get that claim concluded. Obviously, if you have a third-party recovery, the claim concludes, and in most states, there's a future credit that you can apply, and it is as good as shutting down the comp case or settling it. But all too often, we see claims adjusters saying, wow, by the way, supervisor, I can close down this file and settle it out if I just waive the subrogation lien. Eyes light up. What does that mean? Well, that means my claims adjuster no longer has to spend time on this file, and personnel are expensive. So that's good. Number 2, we can close everything down, put this file in the circular drawer and be done with it. And all we have to do is waive subro. Okay. Well, you're waiving subro, that's fine. If that has some benefit to you, great, but do a cost analysis first. For example, if you have a $50,000 lien, and you are waiving that lien in order to have a reserve takedown of $7,500 on an open comp claim, that's not a smart monetary decision. Now, true, you do have to keep a claims adjuster busy on the file until subrogation is resolved. But whether it's a case of the tail wagging the dog or the simple fact that insurance companies see their primary responsibility is that of concluding claims, we all too often see a client with a significant subrogation potential waive a big lien in order to make a claim go away or to make a third-party overclaim, an indemnity action against the employer go away, or some sort of intentional act claim go away. And I'm not suggesting that you shouldn't do it, but the mistake I'm referring to is stepping over dollars to pick up dimes, where you waive a lien that is considerably more valuable than the benefit you're getting by closing the claim.
And on a related note, it's the idea that a lot of carriers, a lot of adjusters think that, and all attorneys are similar, that an attorney is an attorney is an attorney. And the fact is that is just simply not true. Work comp defense attorneys are not trained to give a value to the third party case, right? We are, as subrogation counsel, plaintiff's attorneys. I can take a look at a case and give you a pretty good idea of what that third party settlement's going to be. Take a look at our allocation formula in the state and let you know some sort of very reasonable estimate as to what I think our final recovery is going to be. Also, what that future credit could be, which the future credit could be way more than the amount paid to date, and it could be 10 times more than what you're getting as a benefit on waiving the subrogation lien. So one thing I would say is you can't just rely on work comp defense counsel, right? A lot of work comp defense attorneys, are great attorneys, but they might come to you and say, make these recommendations. But the fact is they are not in that position. They're dealing with primarily administrative defense. And when it comes to third-party litigation, while some of those firms may also do liability defense, that's not always the case. So for many of my clients, I actually serve as national subrogation counsel for them on these claims, where I come in even on cases where I'm not representing them to actually give just a brief opinion as to the value of the third party case so they can make an appropriate evaluation. So this isn't to say at all, and this rule number 9 isn't to say, hey, never waive your subrogation lien. It's more so saying be very, very careful in doing so. Be sure you're considering all facts. You're considering the total value of that third-party case, how much money you'd get under an allocation formula. Let's say we think that I take a look at it. I say it's worth $1 million, probably 80% chance of recovery there. We then bring it down to about 800,000. We put it into an allocation formula. I can tell you a ballpark of what your case is worth. So if it's if I think you're going to get $500,000 on your $750,000 lien, well, guess what? Taking 50 grand, as a benefit off of reserves to waive your lien and to close out the comp claim isn't going to be worth it. So always be very careful, be very strategic. And if you have questions, bring in subrogation counsel to give you an opinion. So finally, we have subrogation and the Flat Earth Society. I love the reference to Flat Earth Society here. Hiring the right expert. This is huge. I train all adjusters to become experts in selecting experts. There are so many great experts out there, but there are also so many terrible experts. And we need to make sure we find the right expert for the right job at the right price with the right expertise. Now, Gary, tell me a little bit more about why this one makes the list.
Yeah, it makes the list. It doesn't happen as often as some of the other mistakes that we've referenced, ergo it's number 10. But it does happen often enough and does cost our industry enough money that I thought it worth mentioning. Like the subrogation vendor who's got this deal that's too good to believe in terms of the contingency fee, a lot of experts will gain their way into the inner sanctums of insurance companies with a bunch of PowerPoint videos and, hey, we can be your expert on everything from bicycle chains to nuclear explosions, and we're going to do it at this low rate. Watch out for those things. The value of an expert isn't only his or her expertise. And we have a chart online about Daubert and the gatekeeper function of a judge and how experts, if they're not properly qualified, I don't care how much money you spent on them, they will not be allowed to utter one syllable in front of a jury if they're not properly qualified and admitted to testify as an expert. So that's qualifications is one thing to think about, but and you don't want to have somebody whose resume says, I do municipal wastewater treatment consulting. I also consult on batteries that explode. I'm an expert on accident reconstruction, and I also do construction defects, and am an expert on the tensile strength of materials.
And I fix toilets.
I mean, that should be a red flag, that somebody is fishing for any and all work, and that somebody may not be qualified to testify. I don't know, but it may not be qualified to testify and be admitted as an expert in a court of law. So we're not only talking about the quality and the qualifications of an expert, but we are also talking about something more intangible, which only we will know because we've used a lot of these experts in depositions, in live testimony, at trial, in front of a jury. We've seen how people react, juries react to these experts. You could have, I don't know about Albert Einstein, how good of an expert he would have made. He was surely an expert, but when it comes to communicating an opinion in a cogent and convincing way to a jury, yet alone to the attorney who's trying to understand what the opinion is, not all experts are created equal. Some of the most qualified and overused experts in the industry will easily flip-flop when presented with tough cross-examination, when asked, well, isn't it true that this might have happened? Well, yes, it's possible. All of a sudden, you've created doubt in the minds of the jury. I always take my experts and I say one thing to them. I say, I want you to repeat this sentence after me. Yes, the product was defective because X, Y, and Z, and because it was a producing cause of the injuries sustained by the employee. Can you say that? Yes, that is your opinion. Yes, 100% your opinion. By the way, expert, an opinion doesn't have to be 100%. That may be your opinion, but that simply means it's more likely than not in your mind that this was the cause. Could something else have happened miraculously? Possibly. But that's where the expert now comes in and refutes that and says, well, it's unlikely because of this, this, or this. So communication is key. Not all experts are created equal. What we have done over the last 40 years is create a database of thousands and thousands, I don't even know the number, of experts that we have compiled, segregated by area of expertise, cost, which of course is important, and how well they do on the stand, and geography. So just because someone comes in with a snappy PowerPoint and convinces you that, hey, there's the one-stop shop here, your employees will no longer have to roll up their sleeves and dig to find a good expert in this case. They can just call us. You know, they're like the TV lawyer. That's one call, that's all. One call isn't all with experts. You have to get the right expert. And even if you're not entrusting a file to us, even if we never see the file, we want our clients to know that you can call us and we will help you find the right expert.
And it's about being strategic in finding those experts. I'll use a different expert for a $10,000 water supply line failure than I will on a $2 million catastrophic fire, right? Caused by maybe a dehumidifier. It's different experts for different purposes at different costs, right? I mean, I don't necessarily need to worry about how my expert's going to hold up in a deposition over a $5,000 toilet supply line failure, right? In that case, we just need a failure analysis and figure out if we can come up with a decent enough argument. On the larger losses, I'm interviewing these experts. I'm asking the engineers questions. I'm making sure that I understand, have you been deposed before? What was the results? Where do you stand on this? And going into depth, making sure, because it happens, frankly and sadly, quite often, clients reach out, they'll say, hey, we have this case with another firm. Our expert totally just destroyed the case by negating his initial position in a deposition. Is there anything we can do? And the answer is usually, sure, but it's probably your case is now worth, half as much as it was previously for all intents and purposes. So it's really important to ask those questions up front. Be strategic. And finally, any chance I have to mention this, I do, don't ask for a written report, right? If that was kind of an honorable mention here is when you have a product liability case, if counsel is not retained, keep reports oral. Don't ask for written reports up front until counsel has time to review the case, and we produce that with consultation with our expert when required to by court order. Right, Gary?
Yeah, and don't forget too, in the smaller files, auto file problem, don't forget a good expert might be somebody with the name Bob on his shirt. The dirty fingernail guy often relates to a jury a lot better than the guy with the PhD, which you couldn't afford anyway in a smaller file. So we have to be resourceful when finding our experts.
That's the truth. And creatively use experts, right? There's a lot of situations where even on smaller auto claims or mid-size auto claims, a reconstructionist, if sent out in a reasonable amount of time after the fact, be it to take tread marks, take measurements and so forth, I mean, it can be worth its weight in gold. So consider experts strategically, consider who to use, when to use them, and so forth, without just having some broad template-based, hey, we used ABC Consulting for all of them, right?
You bet.
Beautiful. Well, that's the top 10. I know there's quite a bit more we could talk about today, Gary, and I have a feeling that you'll be back on the podcast to join me, to co-host, and probably host some of these yourself sometime soon. But that's really all I have. Gary, anything else you want to add before we sign off today?
No, I appreciate the opportunity. It was good to go over. If anybody in the audience has any questions, just feel free to contact us.
Yeah, feel free to contact Gary, myself. We're always here. Again, thank you all today for attending. This is the Subrogation Support Network podcast. Look forward to talking to you all next week.